Hello, all of my new agents. Today, I wanted to talk a little bit about disclosures. So, as you're showing buyers property, because we've talked a lot about buyers and buyers representation contracts and how to find buyers and all those things. When you're showing buyers property, you are going to get the seller's property disclosure statements. And that's what this 10-page document is. Now, it's 10 pages, but there are two radon pages at the end. Those are not technically included in the total pages of disclosures. Why? I don't know. You got to get on the forms committee and ask your state. That's how that works. Now, these are the seller's property disclosure statements. And these are required. This is Minnesota. So these are required by Minnesota statute that a seller, with some exceptions, which we'll go over on page 9, are obligated to disclose to prospective buyers all material facts of which seller is aware that could adversely and significantly affect an ordinary buyer's use or enjoyment of the property, or any intended use of the property of which the seller is aware. So really, any warts that a buyer needs to know about a property that's going to mess with their use of the property or their enjoyment, the seller's got to disclose it. What I used to tell my sellers all the time were, if your property has warts, buyers are willing to overlook those warts as long as you let them know that they're there. Okay. So if you have had a leak in the basement at some point and you have fixed it, you've mitigated it, you've done all the things you're supposed to do, totally fine. That's great. Just disclose it. Because if the buyer finds out later, they're going to have an issue and you could be liable for anything associated with that. Okay. As a buyer's agent, you should review these disclosures with your clients before your clients write an offer. Now, sometimes you don't get these disclosures before you write an offer, and at that point, you would put into the offer a contingency saying, "This offer is contingent on my buyers reviewing and accepting the seller's property disclosures within 5 days after final acceptance, or 3 days after final acceptance." With the understanding, sorry, not understanding, wording with the wording that if your buyer is not okay with the seller's property disclosure statements, they have the right to cancel the purchase agreement and retain their earnest money. Okay. Now, material facts, that's the biggest piece. These are anything that could mess with the use or enjoyment of the property. Now, it also says intended use of the property of which the seller is aware. So if your buyer, let's say a buyer's buying a lake home and they want to expand the kitchen or put three more bedrooms. We'll use bedrooms. They want to put three more bedrooms on the house that they're looking to buy. And if the seller becomes aware of that fact and knows that the septic system can't be expanded to give you three more bedrooms because of whatever rules, the county rules, the loam in the dirt, whatever the rule is, the seller now needs to disclose that fact to the buyer and say, "Hey, Mr. Buyer, I understand that that's what you want to do and that's your goal. However, this is what I know that would prohibit you from doing that." Okay. Now, here's the piece of this that can't just be done verbally. It has to be done in writing, which is why we have this big disclosure form. Everything has to be in writing. Okay. Now, once you have an accepted purchase agreement together and your buyer has reviewed all of the disclosures, they've accepted them or moving forward, but something happens to the property. Their water heater breaks and floods the basement, or a storm comes through and a tree falls on the roof. The seller is obligated to continue to notify the buyer in writing of any new disclosures that need to be made. Okay. So please keep that in mind as a buyer's agent. If you know something's happening, that seller and that listing agent have to give you something in writing that's disclosing those facts. Now, we as a company always recommend that you have those extra disclosures on the amendment to disclosure statement form so that everybody has signatures. So we have verification that everyone's seen it, understood it, and that the disclosure was given. Okay. In writing, best practice is always with signatures. Okay. This also is not a warranty or a guarantee of anything working. Okay. If the seller on the disclosure statement says, yes, the microwave is in working order, but it's actually not, it's not a guarantee that it's going to continue working. It's not a warranty that the seller is going to replace it after closing. This is to the best of the seller's knowledge that, yes, this thing is in working order. Okay. This talks about what residential real property is. Seller's property disclosures are required on residential real property. They are not required on commercial property. Vacant land can be a hit or a miss. We always recommend you do vacant land disclosures for our company, period. Then as we go on through the disclosures, it talks about instructions to the buyer. Your buyers are encouraged to thoroughly inspect the property and not rely just on these disclosures to tell you all of the things. That's why we recommend they get a home inspection. That's why we recommend they go and see the property. Buying sight unseen is not illegal, but there could be issues with that if this buyer doesn't actually see the property. Now, this is a big thing that I think a lot of agents don't know about is that if the seller answers no to any of these questions on the disclosures, it does not mean that that does not exist on the property. It just means that the seller is unaware of anything that has happened. For instance, let's go back to that basement leaking, right? If the basement is leaking and the seller answers no on the disclosures, you can assume that the seller doesn't know that the basement is leaking, right? So just because they've answered no doesn't mean that they're saying nope, never has been, never will be. Just means that no, I'm not aware of any leaking. Let's say the seller is a old lady. She hasn't been downstairs in 10 years. She has no idea what's down there in the basement. And so she answers no because she doesn't know of any leak. She hasn't been down there to see herself. She's unaware that there might be an issue, which is also why it's important for your buyers to have those home inspections. Um, Now we go on to say these are the instructions to the seller, right? We're telling the seller they need to complete this form yourself. Um, as a listing agent, do not fill out these disclosure forms for your client unless, this is the only unless, your client has no one else that they can rely on to fill out these forms and they are physically unable to do it, to fill out these forms. Let's say they have Parkinson's, okay? And they can talk, but they can't write anymore. They physically cannot fill out these forms. In those instances and only those instances, should you help the seller fill out these forms? Now, that does not mean you're answering these questions for the seller. What you're doing is you're asking the seller each one of these questions, saying, seller, what date did you acquire or build the home? I acquired it in 1942. You put those things in here, right? And then at the very end of the disclosures, if you do that, you need to put on the other category that this was filled out by the listing agent at the seller's direction so that everybody's aware that you're the one who physically filled out the form, but all of the answers were given to you by the seller. Okay. Now, if there is any way around that where you don't have to do that, if they have a caretaker who can answer the questions and fill out the form for them, if they have a spouse that can do that, do that. Do that all day long. You do not want to be in court saying, "Oh yeah, I did fill out these disclosures because I didn't think about, you know, whether or not these answers were right or not. I just was trying to help. I just was trying to make this quicker. I just had to get the property on the market." Don't do that. Okay. The seller needs to fill out these disclosures, period. Seller can consult prior disclosure statements from when they bought the home or inspection reports. They're describing the conditions affecting the property to the best of their knowledge. So again, that no in here means that the seller is unaware, not that the problem doesn't exist. They also should attach additional pages with their signature if they need more, if they need to elaborate on anything or give inspection items that are associated with the disclosures. And then they should answer all the questions. If any items do not apply, write NA, which means not applicable. Okay. Those gives you the instructions and the state rules associated with it. You will see at the top of this form that there's a date. This date here is only a reference date. We as agents are allowed to fill this out because this is the date that we are preparing the form for whoever we're preparing it for. Okay. Now, we won't fill out this line 2 until we know how many pages we're going to be putting with these disclosures. Because anything that you attach, reports, records, maps, surveys, anything that you would put with the disclosures becomes a part of this disclosure. So this could be 60 pages long. Now, most of them you will see are 10 pages. Okay. So this is the date that we are preparing the form and just becomes a reference date for any amendments to the disclosure statement, or if we need to reference these disclosures in the purchase agreement. We would say in reference to disclosures dated that date, August 14th. Okay. That's what that is. Then we would fill out, we would have the property information here. And if you're using Instanet, a lot of this stuff will fill in for you, right? But we can fill out that as the agent because it's the property address. We are preparing the form for the seller. Everything else after that, we do not fill out. We have the seller fill out. Now, these are going to ask questions about the home. So, as a buyer's agent, you should be the home and the property. As a buyer's agent, you should be reading these and making sure there's nothing significant that you need to call your buyer's attention to because your buyer is not an expert in what all of this information means or what the effects it could have on their purchase of this home or their use and enjoyment of it. So it is on you as the agent to read these as well and not rely on your buyer to know what these things mean. Okay. As First questions. What date did the seller acquire or build the home? Then they would put in a date. What type of title evidence do they have? Do they have an abstract? Do they have a torrens? Is it unknown where the location of the abstract is? Maybe they're not in possession of the abstract and they don't know what it is. They don't have an owner's title policy. And so you, as the buyer's agent, would be thinking, oh, if my buyer wants an abstract, but the seller's unaware of where the abstract is, that might be a more significant cost because remaking an abstract can be anywhere from $800 to $3,000, depending on how many records have to be pulled. So that is something that a buyer's not going to know. They're not going to pay attention to. So knowing type of title evidence, where the abstract is, has the seller ever have I'm so sorry. Has the seller occupied this home continuously during their ownership? Maybe they didn't. Maybe they were in Thailand for the last 2 years. And so they put no and they put in Thailand last 2 years. Well, now you know that that home might have been vacant that whole time. Well, that changes the questions that you might ask, or whether or not your seller or your buyer has more of an inspection. Because if it's been vacant for 2 years, maybe there's bats in the attic that nobody knows about, right? Is the home suitable for year-round use? Are you in possession of the prior seller's disclosures? If this answer is yes, The seller has a duty, and then by proxy, the listing agent has a duty to give you a copy as the buyer's agent of those prior seller disclosures. Okay. It's the property a manufactured home. What's the HUD number on the manufactured home? Is the title surrendered for the manufactured home? Now, this matters for financing in particular. You need to know whether or not the property is a manufactured home, because I will tell you there are some homes that I've been in that I could have sworn were stick built, and they were not. They were a manufactured home. And if I hadn't read the disclosures that the seller filled out, I wouldn't know that piece. And neither would my buyers. Okay. What kind of road is the property on? Does the property require flood insurance? Our agents in the Fargo area for sure have to deal with this probably more than the rest of us. What is the flood zone designation? And it is on the seller to disclose anything that they know. Now, if they answer, do you know which zone the property is located in? If they answer no, you as the agent should probably go check. If you think it's close to a river, it's been in a floodplain before, maybe the prior seller disclosures did know what zone, prior sellers did know what zone they were in, and these current don't. Have you ever had a flood insurance policy? Okay, all of those good questions. Go on to the next pages. Are there any homeowners association, shared amenities, encroachments, covenants, reservations, restrictions, governmental requirements or restrictions, easements, other utility or drainage easements? If they answer yes to any of those, line 77 and 78 should be filled out with some kind of why was this yes? If there are covenants and restrictions, you need to be getting your copy of those to give to your buyers. If you're the listing agent, you should just be attaching those covenants and restrictions to the disclosures. They are made part of the disclosures at that point. General condition. This is just the general condition of the property. Has there ever been any damage by wind, fire, flood, hail? If yes, what happened? Okay. And these can be as benign as yes, we had a hailstorm. We had the insurance company out. They said there's no issues. We've never had any leakage. So yes, the answer to this question is yes, there has been damage, but nothing was done because the damage wasn't bad enough to have anything done. Okay. It could also be as bad as yes, a tree fell all the way through the house based on wind. And this is what we did to fix it. Now, if it's that significant, as a buyer's agent, I want to see some documentation at that point. What was the insurance claim? What kind of fixes actually happened? Was there an inspection after the fixes happened, or did the seller do it themselves? Right? If a seller's property got picked up by a tornado right off the foundation and then got dropped right back down, the seller didn't have somebody professional come through and make sure that it was structurally sound. And all they did was zip, 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 a couple big bolts into the concrete. Yeah, that'll be fine. You need to know that as the buyer's agent because your buyer's going to care. Next piece is talks about insurance claims. Have you ever had an insurance claim related to the property? If yes, what? Again, they should be filling out all of these things. Have you ever altered the structure? Okay, so if they've knocked out a load-bearing wall, the answer to this is yes. And then what was done? Have you done any work on the property? And it's very surprising how many times that I've seen this as no when they've owned the property for 30 years. I guarantee they've had at some point an electrician and they're wiring something, or they've wired something. General finishing, Did they have any trim that needed to replace? That those answers should be yes. Yes, there has been work done on the property. We haven't left it and done nothing with it for 30 years. Okay. Are you aware of any work where permits were not obtained? And this can be a big deal, particularly if your buyer is looking to do something with the property later, and you find out that previous owner never pulled any permits for all of the work that was done. And that becomes on the buyer then to fix that issue and pay for it, for all of those permits for the county. Well, now you have to get a permit after the fact, and now you have to get a variance, and now you have to pay for all of these things, and they're not cheap. So a seller is required to disclose this. Okay. This is a new one that was added just this year. Are you aware of any professional remediation efforts to eliminate odors? And in particular, this one came up because of secondhand or third-hand smoke in a property, where someone smoked in a property, and they've brought professional remediation people in to clean the property so it doesn't smell like smoke anymore. And so this is not if your seller rents an ozone machine and brings it to their home and runs the ozone machine. The answer to this question would be no. It's not a professional service. This is not you had your niece clean up your floor because your dog pooped there. Okay? That's not a professional service. The answer to this question is only professional services. So you bring in Service Master, or any other cleaning company that's going to come in and do professional remediation of any kind of odors. The answer to this question would be yes. Okay. Has there been any damage to floor or floor coverings, carpet, vinyl, concrete, floor or floor coverings? Do you have or have you previously had any pets? Yes. What type and the number? Now, when they're saying what type, they don't need to go into like super detail, like Tibetan Mastiff of the fourth kind. Like, that's not the type they want. They just dog. I had a dog, right? Or a cat, or a chicken, or a pig, or a horse. Whatever you had in the home, that's where you say yes and what type and how many. Okay. This talks about the foundation. What type of foundation do we have? On the foundation, are there any of these issues? If the answer is yes to any of these issues, seller needs to give answers. Same thing with the roof. Now, as a buyer's agent, your buyer's insurance company might ask for these disclosures in particular about the roof, how old, what the age of the roofing material is. And I will tell you, if the seller doesn't have this filled out, we need to get something from the listing agent and the seller saying how old the roof is, because your buyer's insurance company is going to need that to be able to issue insurance. Okay. Has there been interior or exterior damage, damage from ice buildup specifically? Because, we're in the Northwoods and so we have these problems. Has there been any leakage at all? Has there been any repairs or replacements to the roof? If yes, to any of these questions, here's where you give more detail. Okay. This one talks about exterior and interior walls and sidings. What type of siding? Is there any damage, cracks, leakage, seepage? All of those things? If yes, answer. Now, this is where sellers can get tripped up sometimes because this is a little different. So, this is talking about all of the appliances, heating systems, electrical systems, mechanical systems within the property. And what the seller is saying is that either yes, it's in working order, or no, it's not in working order, or NA, meaning it doesn't exist within the house. So I have a home that doesn't have air conditioning. I answer NA to this question. It does not exist within the house. I don't answer no, that it's not in working order. because it doesn't exist. Okay. I do have an air exchange system as a seller, but it doesn't run because a part needs to be replaced. So I would answer no, it is not. I have an air exchange system, but it is not in working order. No. Yes, I have carbon monoxide detectors and they are working. Yes, my ceiling fan work. I should hope so if I don't have any air conditioning. I don't have a central vacuum. Most people don't nowadays. However, they are very handy. Okay. Clothes dryer. If a seller is not willing to sell the washer and dryer with the property, then they should be answering NA to these questions. If they are willing to sell it with property, then they should be answering either yes or no, whether it's in working order or not in working order. Okay. And that's same thing goes for the air conditioner. If they have a window air conditioner that can be removed, that becomes personal property. It's not attached. And so if they want to take that window air conditioner with them, then this answer needs to be NA. Even if they have the air conditioning, which is something you as a buyer's agent need to check, right? Is the air conditioning with the property? Does it come with? And if it doesn't, you need to check with your buyers to see if you need to include it in the appliances on the purchase agreement. Okay. And it goes into a whole bunch of different things. Environmental remediation systems, if there's a radon system in the house, if there's a freezer, if there's a sump pump, if there's a propane tank, and is that propane tank rented or owned? Okay. All of these things. And then any other pieces that they want to include. Okay. Go on to page 5. And now we get to the more easy part of the disclosures. Okay. Is that a lot of this stuff is the very important things that buyers need to know about the properties. This is not all of the disclosures that need to be made. This is most of them. Then we get to more broad disclosures. Are there any items or systems connected or controlled wirelessly and need a cloud or a gateway to get to? And if the answer is yes on this, like let's talk about a Nest thermostat, right? So you've got the Nest thermostat on your wall of a property that you're trying to sell. Well, that Nest thermostat is a part of the property. That is a fixture. That has to stay there unless the seller excludes it specifically in the purchase agreement. But seller also has to give access to the buyer after closing to that cloud service, that gateway service, that wirelessly controlled item that controls the temperature in the house. And so this is where the seller would disclose those things. Yes, I have a um, Nest thermostat in hallway or whatever the thing is, right? Okay. So now that's a piece that you as the buyer's agent need to know about so that you can follow up and make sure at closing that all of these things get transferred to the buyer correctly. Okay. Now, septic system. This talks about the septic system. Seller either does or does not know of a subsurface sewage treatment system. Most of us just call them septic systems. They're also known as SSTS systems. This is asking, does the seller know of one of these? If the answer is does, then they're required to do another disclosure statement about the septic system specifically. Okay. If the answer is does not know, then they get to skip to E. If the seller does know, but it's an abandoned septic system, then they have to fill out the disclosure statement for the septic. Okay. Same thing with the private well. We have a couple different options here. Seller does not know of any wells. Okay, well, that's easy. Now we can skip on to the preferential property tax treatment. Seller does know that there are one or more wells on the property. Excuse me. Um, Now they have to fill out that disclosure statement for the well specifically. Okay. Maybe the seller knows that this isn't a special well construction area. There's only so many wells that are allowed to be drilled. We don't run into this quite a bit. Maybe our people in North Dakota do. But this is very uncommon to be in a special well construction area, but it is very important to know as a buyer whether or not they are. There are wells serving the above described property that are not located on the property. Maybe they put a well in and then they found out later that the well is actually on their neighbor's property. Okay. Maybe they're in a special well construction area and there's four houses in an area and they all share the same well, but the well is not located on the property that your buyers are buying or the sellers are selling. That's when these things would come into play. Okay. Now, property tax treatment, preferential property tax treatment. There are some people who get breaks on their property taxes because of their status within society. So disabled veterans, Green Acres, CRP, Rural Preserve. If it's a nonprofit building, churches in particular, they get a break on their property taxes. So the seller needs to say, you know what, yes, I am a disabled veteran. I do get preferential property tax treatment, and yes, those would terminate upon the sale of the property unless the buyer is also a disabled veteran, and then they would have to apply as the buyer. Most preferential property tax treatment, and I say most, not all, most will terminate upon the sale of the property, to a new buyer. Okay. There are some that don't. A nonprofit status, if it's nonprofit to nonprofit, then that might rule preserve, right? If you're also entering into the rule preserve agreement that the sellers currently have, then that might not change. Okay. Notice and special assessments. Seller has or has not received a notice regarding any proposed, ongoing, or completed improvement project from any assessing authority. So that's your HOA, that's your city, that's your county, any assessing authority, the cost of which may be assessed or is currently assessed against the property. If they answer has, they have to explain. So what this is saying is that if the city, the county, the township, the HOA, the common interest community, if any of those authorities, assessing authorities, have given notice to the seller that says, hey, seller, we're going to put in curb and gutter in front of your house, and we're just going to assess the cost on your taxes. The seller has to disclose that and has to give your buyer copies of that. Now, in the purchase agreement, which we'll get to later, not today, in the purchase agreement, it says seller has or has not received any notice. And as the buyer's agent, you fill that out on the purchase agreement based on this question, based on how the seller has filled out this piece of the disclosures. If the seller gets notice, well, you are in a contract and have a fully accepted purchase agreement, they have to give you that notice immediately. As soon as they get it, they have to give it to you. Okay. Now, FERPTA, yay for FERPTA, Foreign Investment in Real Property Act. If the seller of a property is a foreign person, it becomes the buyer's duty to pay taxes for that seller because that seller is a foreign person. And this has to do with a whole bunch of legal and accounting and taxation and federal rules that are not my forte. However, You need to know as the buyer's agent that if seller is a foreign person, your buyer needs to go talk to legal counsel, tax advice, something to that degree, so that we make sure that our buyer's not paying for taxes that the seller owes because that seller is a foreign person. I have yet to come across a seller who is a foreign person and where FERPTA has been applied. However, if the answer is on this, you might want to make your purchase agreement contingent on your buyer talking to legal or a tax accountant to be able to understand what their liability is as the buyer in relation to FERPTA and the sale of this particular property. Okay. This goes on to talk about all the rest of FERPTA. Now, methamphetamine production. It's either an is or an is not. Seller is not aware of any meth production or is aware. If they are aware of any meth production, they have to use the methamphetamine production disclosure statement. And that'll be another piece of the whole disclosure statement. Okay. Now, notice regarding airport zonings. This is just a blanket disclosure saying the property may be in or near an airport safety zone with zoning regulations. Okay. Says if you, meaning the buyer, would like to determine if such zoning regulations affect property, you should contact the county recorder. So what this is saying is that we as a state are just making a blanket disclosure to all buyers saying, listen, we might be in airport zoning. You need to go check with the county and make sure that we are or are not in airport zoning. And that becomes on the buyer or the buyer's agent to do that. Okay. This talks about carbon monoxide detectors. Again, blanket disclosure for all properties. Carbon monoxide detectors are to be located within 10 feet from all sleeping rooms. Carbon monoxide detectors may or may not be personal property and may or may not be included in the sale of the home. This is a statute required disclosure, okay? Carbon monoxide detectors have to be in the home within 10 feet, but some of them are not fixtures in the property. And so you as the buyer's agent need to know that as you're going through the property on whether or not those carbon monoxide detectors should be included in the personal property section of the purchase agreement or on an addendum. We'll talk about that later too. Cemetery Act. Seller has to disclose if there are any human remains, burials, or cemeteries located on the property. Okay. Again, this is going to be answered to the best of the seller's knowledge. And a buyer who buys a property with human remains, burials, or cemeteries um, cannot destroy it, move it, molest it. Don't like that word. Can't damage it. Okay. So this is why it needs to be a disclosure that yes, we do know that grandma's buried under the big rock in the back of our 120-acre parcel. Okay. Mm. And the buyer needs to know that piece. Environmental concerns. So if the seller knows of anything in here, insect infestation, asbestos in the property or on the property, diseased trees, formaldehyde, hazardous waste, mold, underground storage tanks, particularly on farms, might have underground storage tank. Okay, they have to disclose those things. And it says previously existed or currently existed on the property. Okay. So even if it's been even if previously, you know what? Yeah, we did have lead paint on the windows when we bought the property, but we replaced them. You still have to disclose that there was lead paint windows on the property. And then you fill out, and then the seller would fill out the other piece. Like, yep, lead painted windows replaced in whatever date. Again, all properties have warts. Buyers are willing to accept the warts as long as they're disclosed. Okay. And then it goes on to say, have you ever been contacted as the seller or received any information from a government authority talking about environmental contamination affecting the property? So maybe they got something from the government that said, hey, listen, we know that there's a significant amount of diseased trees in your area and affecting your property. Here you go. But the seller says, nope, I've never seen any of that. I'm unaware of that. Maybe they answer this question no, because they're unaware of any diseased trees. However, they did get information from a governmental authority saying that there were diseased trees. That would be important for your buyer to know. Now, does that governmental authority are they always right? Maybe not, but that might change the type of inspections your buyer asks to do in the purchase agreement. Okay. And then this goes on to talk about remediation of any public health nuisance. Usually this becomes leaking septic systems. Okay. Then we go on to radon, and we disclose about radon about 800 different times. Okay, radon is a problem. It does cause cancer. Elevated radon concentrations do cause health problems. We know that. Radon tests are encouraged just like home inspections. Okay. Seller has to disclose whether or not they know that a radon test has or has not occurred on the property. And then they have to describe anything that they know about that test, about a mitigation system, or any remediation that has happened. Then they have to disclose whether they have a radon mitigation system already on the property. Now, chronic wasting disease. Chronic wasting disease is a animal issue, usually in deer. Chronic wasting disease has to be disclosed by the seller. If they say yes, they know that there has been chronic wasting disease detected on the property, then they have to fill out the extra disclosure statement talking about the chronic wasting disease. Okay. Now, this is any other material facts, defects, additional comments that the seller needs to tell the buyer. Because remember, these disclosures are a broad overview of most things that a buyer wants to know about, but it might not include everything. Okay. So this is a space for them to talk about, is there anything else you need to tell the buyer that would affect their use or enjoyment? This is where it's going to be. Then it talks about water intrusion and mold growth. And these are the rest of these are notices or state required disclosures that are blanket for the whole state. Okay. This talks about water intrusion may occur in a home, in all of our homes. It just does. You leave a window open, water, and it rains really hard, water's going to come through the window. Okay. And this is just giving a notice to the buyer, hey, there could be water intrusion in the home. You should get whatever tests you want to get. Okay. And here we have again the Predatory Offender Information Act, which we talked about with the agency form and with the buyer's representation contract. But if a buyer wants to know whether or not there's predatory offenders in the area, they have to go to this website or contact the Department of Corrections. That is not on the seller or the agent to disclose. Okay. Now, this talks about the exceptions to the seller's disclosure. So by state law, the seller has to disclose anything that could affect the use or enjoyment of the property to the buyer. However, the state statute also says that there are some exceptions to this rule of material fact disclosure. The first one, and I get so excited about this because agents forget all the time what the exceptions are because we usually don't deal with them. We usually always have disclosures, but there are some exceptions where we don't have to do them, okay? And so this is the area in the disclosures where you can go easily find. I mean, you could go look at the statute, but this is the area right here where you could go easily find if your situation is in the exception. Okay. First one, real property that's not residential real property. Okay. So it's a commercial property. Disclosure is not required. A gratuitous transfer, a transfer pursuant to a court order, a transfer to a government or governmental agency. So we as a seller don't have to disclose to a governmental agency. Okay. A transfer by foreclosure or deed in lieu, a transfer to heirs or devisees of a descendant. Okay. So if I am inheriting a property from my grandfather, he doesn't have to disclose to me because I'm an heir of his estate, probably because he's passed on, right? There is no one to disclose anything. A transfer from a co-tenant to one or more other co-tenants. So let's say it's a twin home, right? They share a wall. Both people who are living in each one own the property together, and one of them decides they're going to sell their whole interest, so only one person owns both twin homes. In that case, material fact disclosures do not need to be made. Okay. A transfer made to a spouse, a parent, a grandparent, a child, or grandchild of the seller. Please remember, this does not say aunt, cousin, uncle, niece, nephew, your person that you graduated college with. In this specific instance, spouse, parent, grandparent, child, or grandchild of the seller, disclosures are not required. Okay? To anybody else in the family, it would be required unless they're an heir and the seller's dead. Okay? Transfer between spouses from a marriage dissolution, also known as a divorce. Okay. A transfer of newly constructed residential property that has not been inhabited. This is this is a builder builds a home, it has never been inhabited. Disclosures are not required in that because there are state statutes associated with a new construction purchase agreement that are different. Okay. That does not mean someone who built a home, moved into it for a year, but still sees it as a newly constructed residential property. They still need disclosures. They lived in it. Okay. An option to purchase a unit in a common interest community. A transfer to a person who controls or is controlled by the grantor of those terms are defined with respect to a declarant under section blah, blah, blah. A transfer to a tenant who is in possession of the residential real property. So renter is renting a property from the landlord. Landlord goes to the tenant and says, "Hey, do you want to buy the property? I'm going to sell it. You already live here. Do you want to buy it?" Renter says, "Yeah." The tenant says, "Yeah, I do. I want to buy it." Okay, cool. As the seller, you already rent the property. You already live here. I don't need to make any disclosures to you per state law. Okay. And then a transfer of special declarant. I wish people were on here so they could tell me if I'm saying that wrong. Rights under section blah, blah, blah. Those are the big ones you need to worry about. Real property that is not a residential real property. Okay. Transfer made to one of these family members. Transfer between spouses from a divorce decree. Newly constructed residential property. And a tenant. Those are the ones that we usually run into where disclosures are not required. Most of these other ones we're not a part of as real estate agents. Then we talk about radon. Okay. Now this is about exceptions, okay, within the statutes. The seller disclosure requirements do not apply to 1 through 9 and 11 through 14. Sellers of newly constructed residential property must comply with the disclosure statement disclosure requirements of Minnesota statute about the radon awareness. So no matter what this is saying is no matter what, 1 through 9 or 11 to 14, those sellers still have to disclose about radon. Okay. Now, buyers and seller can agree to waive the disclosure requirement in writing. That's an option on the seller disclosure alternatives. Okay. No duty to disclose. There's no duty to disclose the fact that the property is or was occupied by an owner who is or was suspected to be infected with HIV or diagnosed with acquired immunodeficiency syndrome. Okay. So if someone on the property had HIV or AIDS, that does not have to be disclosed at all. It's nobody's business. It does also not have to be disclosed if the site, if a suicide, accidental death, natural death, or perceived paranormal activity. If there's a ghost, they don't have to disclose that, no matter what your religion. Okay. If your seller wants to disclose that there's a ghost, they can. It might affect the sale of their property, either badly or goodly. I'm not sure. Then sellers do not have to disclose whether the neighborhood contains an adult family home, community-based residential facility, or a nursing home. Okay, that's something on the buyer to go find if they care about those. Again, we talk about predatory offenders, and that there's no duty to disclose any of those informations. Okay. Ugh. Then we talk about inspections. Seller is not required to disclose information relating to real property if a written report that discloses the information has been prepared by a qualified third party and provided to the prospective buyer. So a seller could, instead of filling out these disclosures, they could hire a home inspector who do an inspection, and they could provide that report to the buyer instead. That's acceptable. Okay. That's a qualified third party. Now, the seller does have a duty to disclose any material facts that they know of that contradict any information in that written report. So if the seller knows that there's a leak in the roof and the home inspector didn't catch the leak in the roof, the seller still has to disclose that they know that there's a leak in the roof. Okay. Then here's some more space for additional comments. This is the seller's obligation, the seller's statement. It says to be signed at the time of the listing. Okay. Essentially, seller's saying that these are true to the best of my knowledge. Okay. Also notifies the seller that they are required to continue to notify the buyer of any material facts throughout the process. And then it's the buyer's acknowledgement. Okay. It also says that us as listing broker and licensees make no representations here and are not responsible for any conditions existing on the property. We haven't lived there as agents, so we can't make representations. Okay. This is the buyer's acknowledgement saying that they see all of the property disclosures and that they've been made aware of all of these material facts. And then your buyers would sign. So these are the seller's property disclosures. Now, that's page 10. And if you remember at the beginning, I told you there's 10 pages in the seller's property disclosures, right? These are 2 extra pages talking about radon because we are all about informing the public about radon in particular, okay? Because radon causes cancer quite a bit. And if homes aren't tested, then we don't know. Radon's odorless, it's tasteless, you can't see it. And so the only way to know is to put a radon test in the house and determine if there's radon there. Now, if there's a radon mitigation system already in the house, well, now you don't have to worry about it because there should be tests associated with that radon mitigation system that say that they're under 4.0. I'm going to screw up this word. PQ Lori? Can't remember. But that's the amount. Okay. So this is the radon information. This is going to be in the purchase agreement, in the disclosure statement. The radon information is going to be almost everywhere. Now, this was all about the disclosures. Keep in mind, please read them as a buyer's agent. As a buyer and as a buyer's agent, you should be keeping in mind that if the seller discloses it here, you might want to ask for the seller to fix certain things in the purchase agreement when you first write it instead of waiting for the home inspection. Okay. So if the seller discloses that, yeah, there's a leaky roof, I haven't done anything with it. And then that also comes up in the home inspection, and your buyer asks at the home inspection, hey, you should fix that leaky roof. The seller has every right to say, listen, I already disclosed that to you, and your offer was based off of the disclosures that I made to you already, and you didn't ask for that. Seller has every right to say that. So it's good idea to not only read the disclosures, understand the disclosures, bring up those things to your buyer in the disclosures about the property. That's all I've got for now. Stop sharing. There we go. That's all I have for now. If you guys have any other questions, please let me know. Otherwise, we will talk more about disclosures, alternatives, septic well location map all next time. Talk to you later.